Is it clear to you that a 15-year-old cannot consent to sex with someone your age?
Yes, sir.
When did that become clear to you? Because it obviously wasn't clear to you when this pre-sentence report was prepared, which wasn't that long ago. I mean, these responses are really flippant.
Yes, sir.
It's ignorant to the law, but it's casual. All of these allegations involve the same child. Correct, everybody?
Yes.
That's
And
correct, Judge.
the allegations in 65 and 66 and 67 are all similar, uh, causing penetration of the sexual organ
One is
And the
sexual
mouth.
organ to mouth, yes, sir.
of the child. And on 6.5 and 6.6, these allegations occurred on or about the same date, April 7th, 2024. And one alleges contacting the mouth of the child with the defendant's sexual organ, and then the other, the sexual organ of the child with the defendant's sexual organ. And then finally, 2067 alleges penetration of the mouth of the child by the defendant's sexual organ on or about April 29th, 2024. Although each of these are second degree felonies, which carry with it the same punishment range, no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. The court will note a couple of things. Number one, the defendant's criminal history does not show any convictions at all, correct?
Correct.
And then the pre-sentence report and the probable cause affidavit show that the victim in this case is the same child who was 15 years of age at the time of the event. And according to the defendant's version, among other things in this pre-sentence report, it's summarized with, I stayed at the victim's house and then the victim was in bed. So I made the decision to initiate the act. The victim was okay with it. So I followed through with the offense, followed through the offense. I made the decision to move forward, commit the act, the process to lead to sexual intercourse. This is what the states. And then finally, it states it was consensual. That's your version?
That's what I read
Correct,
down,
sir.
yes.
Mhm. And then there is, even though no criminal history of convictions, we do have a serious substance abuse history. that's listed here. Marijuana from, how old are you now?
33, sir.
Okay, from the age of 12 to 10 years ago. So that would have been about 10 years in length. You say you used marijuana daily for a decade.
Yes.
That's true?
Yes, sir.
Cocaine, uh, daily from 15 years of age until 10 years ago. So about 8 years.
Yes.
You're using cocaine daily.
Yes.
So marijuana daily, cocaine daily.
Yes, sir.
Then synthetic marijuana you used for a few months
Yes, sir.
when you were 18.
Around that time, yes.
It says date of last use, 18 years of age.
Okay. Yes.
And then age at first use, 18.
Yes.
So, and you reported that your primary drug of choice was cocaine, stating that you used the substances because, quotes, you didn't want to feel. I don't understand that. What does that mean?
The cocaine would numb any sort of emotional feelings. So I used it to kind of just medicate myself to, I guess, live. If that makes
Sir?
any sense. To just kind of medicate myself to try to be in an okay mood or happy mood. Is what I thought at the time.
Mm-hmm. According to the probation office, although the recommendations in the summary portion of this pre-sentence report states that although you reportedly took your full responsibility, your written and verbal statements minimize your conduct. You state, according to this, it was highlighted you initiated the act and that the victim was okay with it, and that you described the behavior as consensual, which is what jumped out from my highlighting that I read in that, because all of that is inconsistent with the law.
Yes, sir.
It's not the way the law works. And also, it goes on to state that investigators recovered text messages in which you acknowledged the victim's age and made statements that could be interpreted as attempts to influence or manipulate her. I'm not sure what that really means. I tried to figure out what that was in all of this. Can anybody elucidate that for me? I don't understand. What did you mean by that, sir?
I'm not sure what it's referring to.
I think it's
All right.
just referring to the communication between he and her in the sense that opened up activity for future dates.
All right. Are there any objections to this pre-sentence report?
No.
And then it is, again, made a part of the record for all purposes. Is it clear to you that a 15-year-old cannot consent to sex with someone your age?
Yes, sir.
When did that become clear to you? Because it obviously wasn't clear to you when this pre-sentence report was prepared, which wasn't that long ago. I mean, these responses are really flippant.
Yes, sir.
It's ignorant to the law, but it's casual. I mean, do you understand? This child is a victim
Yes, sir.
to you, of you.
Yes.
No matter what the child may have been willing to do, they cannot consent to this legally because she's a child and you're the adult. The relationship of you to the child is what?
I was friends with her mother. We were all in a fellowship group, which was 12 step.
And I see these indictments range from in April of 2024. How long of a period of time did this actually occur?
It was just around that time.
A few months, right?
Months?
I it wasn't long. I couldn't tell you exact time. But it wasn't maybe 2 months, 3 months. It was very short.
How did all of this end? Was it reported? Did the police get involved and that's what stopped it?
Someone saw some messages that I think a diary
It was a
that
diary.
the victim was writing, and they reported it to her parents or an adult.
Okay. In each of these cases, an agreement has been reached that whatever sentence shall not exceed a cap of 15 years confinement in prison. So in each of these cases, there are options. You would be looking at no less than 2, no more than 15 years confinement in prison. You could be placed, is deferred or unadjudicated probation an option?
Deferred.
But not regular probation, but
Correct.
deferred is.
Yes, sir.
Is that what the state agrees with and understands?
Yes, sir.
All right. State can open and close.
Judge, all three of these cases are second-degree felonies, with the punishment being 2 years with a max of 20 years.
By the way, the agreement is whatever sentences shall run concurrently.
That's correct.
Okay.
Because the defendant does acknowledge the fact that he engaged in these offenses, that's why the state agreed to the cap. Also, on the flip side of that, when I look at the fact that the defendant does minimize and then he thinks that it was consensual, although the max is 20, that's why the cap is still up there at 15. So the state is going to ask that the court sentence the defendant to 15 years in the Texas Department of Criminal Justice. And I'm looking at the facts of this case alone and how the defendant thinks that he was having repeated acts of consensual sex with a 15-year-old while he was supposed to be friends with her mother in a recovery center, recovering from the drug acts, and then he's victimizing a child on the other side of that. So the state is asking for the 15 years TDC.
Mr. Jeffries, you only has one year left.
Yes, Your Honor. So, Mr. Zambrano is here. He's pled guilty. He's taken responsibility. I understand the concerns about the statement that was made in the PSI, but I would say that Mr. Zambrano made those statements not saying that he's thinking she was giving permission, but that there was no physical coercion involved in it. The consent was not of legal consent, but of just lack of resistance, if you will. And that's not okay. And he understands the legal consequences of that. That's not disputing, and very much part of the reason we pled guilty to everything. Taking responsibility. The PSI also indicates that he would be a low risk should probation be an option. They've listed many conditions that he would have to comply with. I believe there was 31 of them. He has a clear criminal history. And this is a cap of 15 years.
Okay, we need, just for the record, so that's
Well,
our
other than
clear
this
criminal.
case.
He has no criminal history. He's cleared of any criminal history.
Correct.
Okay.
And the prison sentence that we're looking at is in between 2 and 15 years. If we look at the high end of that and say 15 is where we land, and he's going to come out of prison as a 48-year-old. He's going to come out of prison detached from society with a fractured view on everything, trying to reintegrate. That's still a fairly young individual trying to find his way into our community. And the question is, do we want that coming out of prison at that stage when we have an opportunity to rehabilitate through programming, through guidance, through steps that are available in community supervision situations? Part of the packet which have been turned over to the court is multiple reference letters, many of which are from his church, where he's taking part in recovery programming, which involves him taking responsibility and discussing publicly his shortcomings and his crimes and his behavior, which has led to this point, and taking true steps to correct himself. He understands that this is punishment and it's warranted. And prison is very much on the table as a punishment. But we all know that probation is also a punishment.
Law
And
says it is.
and in this situation with this type of crime, his punishment's going to last well beyond whether we put him on probation or whether we put him in prison, because he's going to be labeled sex offender and treated as such through society from now moving forward. And I would, we are asking the court that you take all that into consideration when making your decision, and just give him an opportunity to grow and be a citizen and correct his behavior and live out his punishment in a way that gives us a 48-year-old person who is in tune with society and ready to take a decent role in life moving forward.
Judge, it's not about what position we're putting the defendant in. The defendant put himself in this position when he made these choices in 2024. Yes, probation, in that report, it says low risk. That conclusion is based off of things that came out of the defendant's mouth. And the fact that he doesn't have a criminal history just says you haven't been convicted or caught with anything else, but his actions are so concerning that I don't think that his actions warrant us to send him back out into the community. And defense counsel talked about programs and placing him into programs. If we look at the facts of this case, that's how we got this victim here, is because he was in a program that was designed to help him deal with his drug addiction, and he victimized someone else in that program. So I'm very cautious about sending him back into the community and putting him back in the face of programs where he has the option to victimize other kids. And when you have an attraction to kids, or you don't know how to say no to sexual acts with kids, it's hard to say we're going to put you in a program and reprogram your brain to say you don't have that attraction. So again, the state is asking for that 15-year prison sentence.
Something that is curious that I don't understand on his substance abuse history. Just states that you were using marijuana from 12 years of age, cocaine from 15 years of age, and the date of last, and the frequency became daily. And the last date of last use was 2016. Is that true?
Yes, sir.
Okay. So that's 8 years before these events, correct? That's what this is on. These sexual assaults of the child occurred on or about April 29th, 2024, April of 2024. So you quit using drugs according to your statements, 8 years before these events.
Yes, sir.
Okay. And then the synthetic marijuana was last used when you were 18 years of age. So you're 33.
Yes, sir.
Well, that would have been 15 years ago.
Yes, sir.
You can't say that the drugs caused you to do this, can you?
No, sir.
Oh, that wouldn't be an excuse anyway. Well, somebody slipped you the drugs, because voluntary use of illegal drugs is not an excuse for committing crimes. But I'm going to give you an opportunity to say whatever you want to say if you wish.
Yeah, thank you. I only stated that it was consensual. I was just trying to be as honest as possible.
A child cannot give a consent by law.
And I'm aware of that now, and I apologize. I didn't mean to say it in that manner. I just wanted to state that I wasn't forcing myself upon anybody. Regardless, I do understand that she is underage, and I carry that.
Yeah. Most of the assaults, sexual assaults of children in this room over 20 years, and me as a lawyer, they didn't occur in an environment where they were placed seemingly under duress, which is because children can be manipulated. And their decisions are they're still learning. You, however, you were an adult.
Yes.
You had the responsibility to show self-restraint, which you didn't do.
And you are correct. I didn't do that. I couldn't talk about it at the time. It was very difficult to open up about that or even remove myself. And unfortunately, once this happened, it came to light. Of course, everybody went away, and at that point, I needed help, and I reached out, and that brought me to church. It brought me to people who have accepted
You've
me.
never been to church before?
No, sir.
Never in your life.
As maybe visiting with other people, but to actually practice.
What was it about having sex with a child that you thought wasn't contemptual or wasn't sinful or wasn't illegal?
It was all of that.
It was.
Yes, sir.
Okay. Okay. But if you knew better, why didn't you act correctly?
At that moment, I decided to follow my urges.
All right.
If I'm being honest.
Yeah, well, that's a good thing to be.
And so when I went to these people from the church, I came with all that shame because I was tired of not being able to.
When did the shame come across?
The shame has always been there.
You mean when you were committing the acts?
With just any sort of sexual act that wasn't, and at the time I didn't really understand it, but I just felt like sex was always something that bugged me, probably due to being exposed to it as a kid. I was very confused. I didn't understand what was okay.
Wait, you thought putting your penis in a child's mouth was okay?
No, sir.
Well, that's what you're accused of doing and what you pleaded guilty to.
Yes,
and
sir.
then placing your penis into the child's vagina.
It's not okay.
Well, you knew that at the time.
Yes, sir.
Look, every case comes before this court, and we have to weigh how serious the circumstances are. All right. And let me just ask you this. How important is the innocence of a child?
Important to the utmost.
Just important?
The utmost.
Well, you took that away.
Yes, sir.
from this child. There's no greater thing for a child than to lose her innocence, unless it's her mind. Her first consensual act of a sexual act should be at an appropriate age and with someone who she loves and they're in love with her. And there is no force but intimacy. You made this whole act ugly,
Yes, sir.
which is the gift that our Creator gave so that we could procreate, continue to exist on and on, generations. What? You seem to understand it and appreciate the seriousness. I don't understand why it took you so long. Why you didn't appreciate it at this time, during this, when this was occurring and the child was being victimized for the rest of her life. I just wish somebody, me or your attorney or somebody would have appeared right before you were about to make this stupid mistake, foolish mistake, harmful mistake, and try to make some sense out of all of this for you so that you made the right choice.
Yes, sir.
That's what I wished. But we can't do that. We got to deal with what happened and go from there. You know, each of these crimes are separate events. Each of these carry their own punishment range. You're looking at really 60 years in prison. Your attorney has been able to fashion not only an agreement where all of these cases, whatever, number one, it's now limited. It's not, it doesn't have a possible maximum length of time. It's less than that. It's up to 15 years in prison. And all of those would be not added separately, but would be running concurrent. Plus 5 cases, 5 other crimes alleged against you would be dismissed. Okay. And each of these offenses are separate acts which could have run concurrently on top of each other, which would have certainly added up to several lifetimes. Well, Mr. Jeffries, a good lawyer, knows how to handle problems. And he does it responsibly. All right. Anybody else want to add anything, please?
Nothing further from the state judge.
Okay.
All right. If nothing further, I'm going to find in each of these cases, that's cause numbers 24 CR 2065, 2066, and 2067, as Mr. Zambrano, Alberto Zambrano, you were charged with the second-degree felonies of sexual assault of a child in each case, a child younger than 17 years of age, namely 15 years of age. You pleaded guilty in each of these cases voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases, which was your confession of and understanding of rights, admitting to guilt. I now find you guilty beyond a reasonable doubt in each of these 3 cases. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years in each of these cases. These will run concurrently. You must now register as a sex offender, and I believe this will be required of you for your lifetime. Two things. I wish, number one, you didn't do this. Somebody could have, you would have realized the right choice. But number two, You were grown up, you knew better. I am more sorry and feel sad for the child and what that child has to live with the rest of her life. A loss of innocence. Her first sexual experience shouldn't have been forced like this. It was inappropriate. It was illegal, and it carries with it severe sanctions. Anything else to add?
Nothing further from the state, Judge.
We're in recess. You were taken into custody, sir. I will dismiss those other 5 cases.